From WKNOW, this is Steve Chanley with One Question Too Many. Today's program is made possible by the law firm of Employer Advocates Group, serving California employers since 2002, with offices in Orange County and San Luis Obispo County, California. eaglawgroup.com.
Thanks for having me.
Is it okay if I call you Phil?
Yeah, absolutely.
So how long have you been practicing law?
So I graduated in 2013, so I'm looking at 12 years experience right now.
Can you tell us about your primary practice areas?
Yeah, so I do a lot of insurance defense and then also a lot of business litigation. I say that I'm almost exclusively a trial attorney, but I say that my specialty is in trial work, meaning litigation, rather than saying I specialize in employment or construction or medical malpractice, whatever it might be. I've done a lot in different fields, but what I consider my expertise, I always tell people my expertise is in litigating and getting them through the court process.
Years ago, I used to work at a plaintiff's firm in Burlingame, California. Joe Cochette was the founder of the firm. And I recall them talking about whenever they got a new case, their objective was to get it into trial as soon as possible. I remember that so clearly. And this was like the summer after my first year at law school. They did not want to fool around with the pre-trial procedural things. To them, those were just road bumps. Do you have that kind of mentality?
Not quite. When I get a case in, the first thing I like to do is to try to figure out where are the off-ramps, where are the places where my client could get out of this litigation. And keeping in mind, I'm almost always on the defense side. So we're trying to figure out where can we get out of the litigation. And obviously trial is always one of them, but I always try to look for if there's alternate routes too. So I sometimes compare myself to a glorified GPS because I'm looking at it and I'm going, if your destination is trial, but maybe your desires or your goals would be better served if we got into arbitration. And what are the steps that we need to take to go to arbitration? Or maybe one of your goals is to make sure that your corporate representative does not see the light of a deposition. And if that's the case, what are the paths that we can take to get you out of that? How can we get out of this litigation without getting to a corporate rep depo? So I kind of see myself more than just saying we're getting to trial as quick as possible, saying here's the 3 or 4 paths that you can take to get out of this case. One of them always being trial, but what are the other ways that we can resolve this in your favor?
Yeah, I think ultimately, while trial is fun, it's expensive and is not always the best option for a client. So I always proceed in that exact same mode of operation. So you've explained that you practice in various areas. Are there certain practice areas that you prefer over others?
Yeah, there certainly are. I list construction as one of my areas that I practice in, but to be candid, it's not my favorite. I'm not trying to attract work in construction. I've just done it enough to know how to handle one of those cases, but I tend to gravitate towards more serious personal injury, serious wrongful death. I won't say that I gravitate towards the most complex business disputes, but I do like business litigation a little more than other areas, just because it presents something a little different than dealing with individuals. It's usually 2 more sophisticated parties, which kind of adds a layer of comfort or maybe ease to handling it that just makes things just go more smooth when everybody knows what they're doing or what they're getting into.
I say that quite a bit. It's always easier to litigate with experienced counsel on the other side.
Yeah, absolutely. I can't overstate enough how much I appreciate when the other side knows what they're doing, but also is collegial and friendly and will work with you. Somebody who's not just going to fight for the sake of fighting, but actually wants to get to the end issues as well.
My philosophy is that's the way it should be, because it doesn't matter which side you're on. We're all officers of the court. So before you joined your current firm, you worked a smaller firm, correct?
Yeah. So I started at a pretty big firm and realized after just a couple months that the culture fit wasn't right for me. And so I acted the opposite way and went to a very small firm, just a few attorneys. And it was a very different experience. And that's kind of when I realized I think of somewhere in the middle, a little bit of Goldilocks there, but I wanted something that had more than just a handful of attorneys, but also wasn't one of these, large several hundred attorney firms.
Can you explain the differences in practicing at various firms of different sizes?
So I found that the larger the firm, the more resources they have. It's a lot easier for a bigger firm to hire somebody to specialize in just handling appeals or handling document review and discovery review and things like that. And it makes it so that you as the trial attorney or you as the lead attorney, you might have to pitch in on those things, but you don't always have to worry about them too much because you have people on your team to do them. When you go to that really small place or a smaller shop, all of a sudden the buck stops with you, and you got to make sure that you know how to handle every task that comes in. And what I found is that in the mid-sized firm, it's nice for me because I get the administrative support that I want. It lets me have somebody who can help me with issues like billing, dealing with audits from clients. But at the same time, I get to be in the weeds on just about every issue on my cases. I get to touch everything on the file because I don't have so much of a specialization that I get to have to pass things off to people to handle instead of me.
How many cases have you tried?
That's always an interesting question to me because I feel like as trial lawyers, everybody talks about jury trials as just the gold standard. We always want to get in front of a jury. So I've tried 2 jury trials in my experience, but I've had about 5 other bench trials that I've done. And then I've also handled an arbitration as well, which I've kind of noticed is pretty par for the course anymore, is that we get jury trials, but it seems like a lot of people get their early trial experience from bench trials, arbitrations, places where you're not standing in front of a jury.
Do you prefer bench trials over jury trials?
As a lawyer, I prefer a jury. It's just so much more fun. It's so much more engaging, and you really get into that storytelling. I think for a lot of cases, though, from my client's perspective, the bench trial or the arbitration is much better for them. Again, I practice primarily on the defense side, and so a lot of times I'm representing a corporation that may not be the most well-liked in society. They're vital corporations. They're things that people need. They're services people need, but we still kind of like to make boogeyman's out of them. And so for them, a lot of times I'm forced to, hey, this would be fun to go try to a jury. This has interesting facts, but let's get in front of an arbitrator. So that way we've got an experienced judge or attorney who knows the law well and isn't going to be swayed too much by bias or societal bias. As a trial lawyer, though, I think jury trial is so much more fun.
You mentioned earlier the issue of being a good storyteller. How important is it to be a good storyteller in trying a case?
I think it's important to be a good storyteller in not just trying the case, but the entire way through. When you try a case, you definitely have to be able to tell a human story. And that's, I think, a lot of the trial methods that we're seeing come out right now are talking about that. Nick Raleigh's got the book Trial by Human, and it really just talks about how can we reach the human story that's underneath the law, that's underneath these rote facts that we talk about, and how can we really bring out the human side of things. And we do that through a story. But I've always, as I've gotten more experience underneath my belt, I've started to mentor more people. I tell them, when you're writing your initial analysis of a case, or if you're writing a mediation statement, don't just go through and recite documents or recite facts. You got to actually tell a story. You got to talk about almost as if you're giving an opening statement to the jury of how did this happen? How did this come to be? And make sure you're telling it from the eyes of your client. Because I think a lot of lawyers default to, it's almost like a police report. They're telling a narrative section inside a police report, and it's just very fact. They take all the feeling and emotion out of it. But I think a good trial lawyer's got to be able to put that back in there when they get to trial.
What point when you get a new case do you start formulating your theory of the case?
Usually day one. I mean, when I first get that file in, the very first thing I do after obviously we check conflicts and we make sure that we can actually take on the case and make sure we've got the client agreement and all that signed. But as soon as we start actually digging into the file or looking at pleadings, I start thinking about what are the trial themes? What are we going to tell people happened here? And as I mentioned this earlier, but it's really important to me that I always do that from the perspective of my client, because I think the default from a lot of attorneys is to think about it from the side of the plaintiff, and partially because that's who got to tell the story first. They filed the petition, they filed the complaint, and so they got to tell their story. And as I mentioned this earlier, but it's really important to me that I always do that from the perspective of my client, because I think the default from a lot of attorneys is to think about it from the side of the plaintiff, and partially because that's who got to tell the story first. They filed the petition, they filed the complaint, and so they got to tell their story. And so from day one, when I'm starting to write that answer, I start thinking about, okay, well, that's what the plaintiff says. What does the defendant say? Who is actually going to be my storyteller at trial? How is that story going to come out? What are the pieces of evidence that I'm going to need to back up my story to a jury, so that way I know that they'll believe me and that they'll follow my side.
Do you ever sometimes use focus groups?
We do use focus groups occasionally. I'll say that candidly, it tends to be if we use a focus group, we're actually more likely to settle that case because we get the perspective and feedback of a group of people that could potentially represent who's on the jury. A lot of times getting to hear how they respond to the story gives us that information we need to actually reach a settlement, whether that's negative perspective, and then we obviously don't share that with the other side. We keep that to ourselves. But if it's something positive we're hearing from that focus group, we'll freely share that with the other side and let them know, hey, here's how our focus group responded to this case. Do you want to talk settlement again before we get to trial?
Is that a persuasive approach with opposing counsel?
Yeah, I think generally sharing information with opposing counsel is persuasive. I think people, especially the attorneys that I'm up against, appreciate getting to see some of what we have outside of formal discovery. I've noticed, and I don't know if this is necessarily a shift or if this is just sort of how I've been trained, but I've noticed more recently, it feels like people are more willing to cooperate outside of discovery. There are still plenty of attorneys who they want to fight over everything. They want to go through formal discovery for everything. But there's also people who just say, let's sit down. Let's just talk about what cards do you have? What cards do I have? We know that we're not showing each other everything, but if I know 80% of your cards and 80% of mine, maybe we can find that exit ramp that's beneficial to both of our clients without having to make either of them go sit through a trial.
Has it ever happened that you didn't settle a case after participating in a focus group, but coming out of that experience, you've somehow changed or refined your theory of the case?
So it hasn't happened to me personally, but I've had a couple partners that have done that. I will say that, even with our size, when somebody at my firm is going to trial, we tend to bring in a lot of people to lay second eyes on a case. And so I've had a couple cases where it's been a partner's case and they got close to trial, would ask me to come in and kind of look at it, review it. And we've had a couple where we've gotten a focus group response that helped change our approach toward how we were going to present it to the jury. Whether that was the focus group saying, we really wanted to know more about this piece of information and he didn't say that, and then us adjusting with, okay, well then we'll give them the answers they want. Or a focus group saying, we really think we would find in favor of you, but we couldn't get over this piece of information. And so having to adjust our message slightly to address that.
In your first few cases, were you the second chair in the case?
So actually, well, I'm going to go way back. So the first jury trial that I ever took part in was before I was a lawyer. I was in law school, a third year clerking at a law firm, and it was in a small county. The firm I was at the time was just about 5 attorneys, and the partner on that case wanted me to go ostensibly just to get experience and just to see a trial. But realistically, he wanted me to go and basically be his second chair / paralegal there. And so the first trial that I ever went to wasn't even as an attorney. It was just basically it's supposed to be just sitting and watching. And then I ended up handling the exhibits for him, taking notes on when he was doing jury selection. I was sitting there with the chart, taking notes on who he should pick, things I heard people say that made me concerned. And so it was an interesting experience that I almost feel like the first trial I ever had was a second chair, but wasn't even as a lawyer. And then the next trial I had after that, after I actually got barred, was when I was a younger associate. And candidly, sometimes I look back at that case and think that didn't make any sense to try at all. It was just a bench tried case, so it wasn't going to be overly expensive, but I think the client wanted it tried on principle more than anything. And so as a result, I was actually able to first chair that bench trial with about 2 years of experience out of law school.
What was that experience like to you?
I think that was really eye opening for me. It's interesting. I like to work with younger people a lot. And so sometimes I have to remind myself that they don't know what they don't know. And I look back on that trial and I think about how much I didn't know that I didn't know. The other side was walking in with a 5-page bench brief, and I had a 1 page that barely covered any case law at all because I didn't realize that I needed something more thorough for the judge. I can recall in that first trial, there was a witness that, because it was a smaller case, we didn't have extensive discovery on it, but there was a witness that I didn't realize was actually going to get called. And so I had to adjust on the fly and really approach it, really take that on kind of in the moment. Now, in retrospect, I try to make sure that I never know who's going to be a witness that I don't know about, and just try to be prepared for everybody. But at the time, I was just going in thinking, there's no way they'll ever call this guy. They can't even find him. They couldn't even find him in discovery for a deposition. So how are they going to find him for trial? And learning that I was wrong on that.
How did you respond to that surprise?
Luckily, I was able to respond pretty well. I had an idea of who he was, and so I had discussed that person with my client in the past, and so I knew the right questions to ask to basically discredit him, but I wasn't able to use him much more beyond that. It's one of those scenarios where you really have to put the skills that you learned in law school about being able to think in the moment and think on your feet. You had to put those to the test and use those in that scenario. I still consider myself relatively young in the profession, only having 12 years experience. I think the reality is that a lot of younger attorneys just haven't had many chances to really think on their feet like that. And I blame that in part on the COVID years. People weren't taking depots, people weren't going to trial. And so we've got people with 5-6 years experience now who spent their first half of their practice never actually doing anything in person, never trying a case, never taking in-person depositions, and they just didn't have to respond to that. So I think it's still, any chance that an attorney can get to practice that skill is great, especially any chance that an attorney can get to really adjust and adapt on the fly. I think it's a great learning experience.
Based on your observations, would you say it's an overstatement to say that for a big swath of young attorneys that the pandemic ended up stunting their ability to develop lawyering skills?
I don't know if that would be an overstatement. I think the pandemic definitely slowed attorney development. And I don't fault any young attorney who came into the bar in that area of time for not knowing some of the skills that they might not know. We were when we've been hiring in the past couple of years, we've always had to take the approach of somebody may have 4 years experience on paper, but really only have 2 years experience in practice because of how COVID has slowed their development. What I'm impressed by, though, is I think a lot of the people who came out of that period of time, at least the ones who have stuck with litigation, have proved that they're really resilient, that they can really overcome adversity, that they can adapt to scenarios a little bit better. And even if it's not adapting, like a witness gives you a statement and you have to call them out on it, they've proven that they can adapt to basically being thrown in completely unfamiliar territory on a moment's notice. That's something that I think is an underlooked and undervalued skill by more senior attorneys.
We speak about mentorship quite a bit on this show. How important do you think mentorship is for professional development of an attorney?
Oh, I think it's huge. I don't think you can have enough mentoring. And that's something that I've prided myself on, is to make sure that I'm mentoring people well. But it's interesting, and I wrote about this the other day on LinkedIn, that I noticed that when I was coming up in my firm, the default style was throw you into the lion's den and see how you come out. And that was considered mentoring at the time. And I've always taken that background and said, I don't like that. I don't like that we just want to throw people into the fire and see if that makes them into iron or steel. I would much rather assess what they know, assess what their skills are, and give them appropriate tasks based on that. I think that's been especially important post-COVID because of again, some people just got more experience than others, and some people got less experience than others during those years. And so it's hard to just look at someone and say, you're a 6-year associate, you know these things. I think we really have to take the time to assess where they are, and adapt our task to them based on that.
You actively mentor any younger attorneys at your firm?
Yeah, I've got several that I mentor at my firm. It's not, we don't have a formal official program, but I've just made it a point to meet with them and talk to them and make sure that I'm talking through cases with them. I also like to do a lot of volunteer work. I like to coach a lot of either older high school or college age kids. So I've got some mentoring relationships outside of that too.
How does that help you in your professional development?
So mentoring younger attorneys really gives me an opportunity to think through some of the fundamentals over and over. And it's interesting that earlier before we started recording, we were talking about athletes who come out and have to learn some of the fundamentals. I think as a lawyer, there's fundamentals you have to know. And sometimes we have to re-practice those. We forget to re-practice them as we get more experience. We think, oh, well, we can just have a paralegal do that, or we can just have a younger attorney do that for us. But mentoring gives me a chance to really think through what are the fundamentals of being an attorney? How am I at those skills? And how can I improve at those skills or keep improving at those skills?
Switching gears here back to trial advocacy, how do you typically go about developing strategy for selecting a jury?
Well, the first thing is I want to know as much background about the people as I can. And it's hard sometimes because some courts will give you the jury questionnaires a couple days in advance, and some of them are giving you it the morning of when you show up to the courthouse. But really trying to identify who's on the jury and what information can I find out about them, both from their questionnaire, but also from doing a quick social media search, doing a quick search of the court records to see if they've got any pending litigation. Sometimes even just Googling. A lot of times whenever I go into jury selection, I'll have a team of people in the background, especially if I know I'm only getting the questionnaires or the names that morning. I'll have a team of people back at the office who are ready to search for those people and send me results. And I've done that for colleagues as well. I sat in the office and just knew they were going to get the jury questionnaires around 9 a.m., be ready to go. We're going to divide up the list among 3 or 4 of us, and we're all going to take our deep dives into each of those 10 to 15 people as quick as we can and get it back to them before they have to actually select who's going to be on the jury. So I think that background investigation is probably one of the most important pieces because it lets me know when I'm standing in the room, who do I talk to, who do I not talk to. It at least gives me a starting point rather than just a room of 45 to 60 people just staring at me. And then once I'm in there, I want to spend some time in jury selection, building a connection with them. I tend to use humor a lot. And really every aspect of my life, because I'm a pretty firm believer if you're not having fun, you're not doing it right. But I had a partner one time who I asked him to review my jury selection outline, and he wrote on the top in big letters, "Don't make so many jokes." He had to remind me that appreciate the gravity of the situation, but I do use a little bit of humor just to sort of lighten the mood, connect to them. I try to make sure that I'm not understating how serious what they're there to do is, but I try to make sure that as the one time that I get to actually have some back and forth conversation with them, that I'm actually humanizing them and humanizing myself, going both ways.
How important do you think it is to be an effective advocate for the jury to like you as a person?
I think it's important. I don't want to overstate it because I think the most important thing at the end of the day is to be authentic. You hear those stories about attorneys who'll go into small counties and bust out a pair of cowboy boots and a dirty blazer because they think it makes them connect more. But I think most people can see someone who's being fake. Realistically, I think as long as you're coming in and being a true version of yourself, people are going to appreciate that. Now, obviously, if the true version of yourself is that you're just a giant jerk, maybe you got to work on that a little bit. But if the true version of you is just an authentic person who's going to come in and acknowledge, look, this is my job. It's not always pleasant. Some people don't like me, but this is what I'm here to do. And I'm going to try to do it as professionally and competently as possible in front of you today. And I hope that you'll respect that. I think that's what juries appreciate.
Would you say that the most important thing when you're putting on your own witness for direct examination is being transparent in the process?
Yeah, I think transparency is important. And more to the point, I think you almost have to be explicit about that. I think there's ways that trial attorneys can acknowledge to the jury or signpost to the jury or to the bench or to whoever is a trier of fact why they're calling that witness. I think the worst thing you want is for you to get 10, 15 minutes into questioning a witness and have the fact finder still scratching her head trying to figure out, why am I listening to this person? What is their relevance to this story? What is their relevance to the case? And so I think as a lawyer, it's really important that one of the first steps you take is you signpost with either maybe you just flat out tell the jury why you're calling a witness, or maybe you just use your first couple questions to establish, hey, here's who this person is, here's why they're important to you, and here's what I want you to get out of them. And if you establish that, then you obviously have to go and do that, because then if you tell the jury, I really want you to get X, Y, and Z out of this witness, and then you spend the first 30 minutes with that witness talking about every other letter of the alphabet, they're going to ask, he told me to listen for X, Y, and Z. He hasn't even reached M yet. What's going on here?
Can you give me an example of how you would signpost a witness?
So let's say that I had a medical expert who I was expecting to talk about. Let's say a plaintiff had back issues, and um, there was some pre-existing history of those back issues. I'm going to, in my first question, probably say, doctor, can you tell me a little bit more about your specialty or how you're experienced in this particular back issue? Doctor, we're going to be talking today about Mr. or Miss Plaintiff's history of this condition. Can you tell me how it is that, you're experienced with that and what your background is? So even though I'm still in that introductory phase of talking about the expert's background qualifications, I use my question to signpost, this is what I'm going to be talking to you about. So that's why I'm asking about your background here, is because that's ultimately what I want the jury to get out of you, is this particular area or this particular condition. I don't think enough attorneys signpost where they're going with trials. I don't think enough attorneys lay out the roadmap. And I think part of it is we know the case too well. And so we forget that somebody who is coming at it with fresh eyes doesn't know where we're going. We start asking questions of that expert, and we know, because we've spent the last 2 years litigating it, here's the big issue. Did this person have continuing and ongoing issues because of a prior cervical fusion? And then you get in front of the jury and you sometimes forget they don't know that that's what's going on. They just see somebody who was in a car accident who hurt their back, and they don't understand that your whole argument is premised around, hey, this person didn't really hurt their back. Their back was hurt before the accident, and we want to pay a fair amount based on understanding that their back was already in this condition. And so I think when you work with a case for so long, you forget that people who are new to it don't know where you're going or where you're headed with every question or every witness or every exhibit.
How do you typically handle it if there are one or two bad facts in your case that you just know will come out?
I like to try to bring them out. There's a lot of techniques for handling those. The one that I learned in law school that's carried with me is just to not necessarily bury it, but just make sure it's not the first thing and it's not the last thing that the jury hears. So, a lot of times we do that with, if we're paying an expert any amount of money, I make sure that I've asked a few questions to establish the expert and establish their qualifications. I might establish that, they were hired to look into X, Y, or Z issue. And then I'll ask a question about, well, let's just get this out of the way. You were paid to be here. My firm's paying you. You're not out of the goodness out of your heart. But that doesn't change the fact that you believe the opinions you're about to give, right? And then I launch into the opinions. And by putting that bad fact in the middle of two good facts, I find that the jurors tend to pay less attention to it.
Would you mind explaining to some of our listeners what an expert witness is?
Yeah, so an expert witness would be somebody who's qualified based on their background, experience, skill, education to look over a case and provide an opinion as to some material fact. And it's unusual because typically courts are so focused on, we only want evidence. We only want the people who witnessed it. We only want the documents that are authentic and original. And expert witnesses are sort of that one loophole of, occasionally it's helpful to the jury to have somebody explain it who knows about it. The most common are probably medical experts, because there's a lot of medical terms that a jury just may not understand, a lot of medical conditions that they may just not understand. But I've had every sort of expert. Engineers who have given opinions on, well, this building was built improperly because of X, Y, or Z. And we've had people who come in and give opinions as to, well, this person was injured and here is the jobs that they're able to do now based on their current condition. We've had economists who are experts in saying, well, here's the actual value. If you're trying to calculate how much somebody is going to lose in income in the future for over the rest of their working career, here's the factors you have to take into account to come to that ultimate decision on what that's worth.
Do you think trial judges view the testimony of an expert witness differently than jurors do?
I don't know if they view it differently, but I think they listen to different things. I think trial judges are a lot more concerned about the validity of the process. They want to make sure that at the end of the day, no one can come back and say that wasn't fair. They want to make sure that at the end of the day, everybody can come in and say, well, it was a chair match, but at least we both got the same chair. That's what the judges are concerned about. And so I think they listen to expert witnesses with an eye towards, are they accurately conveying their qualifications? Are they accurately conveying the fact that they weren't real witnesses to the case, that they're coming in after the fact? Whereas I think juries listen to them a lot more for, they want to see how they're using that chair in the chair match. And they want to see how they're actually swinging around and where they're landing the hits, and they're listening a lot more, I think, to the substance than necessarily the qualifications.
One of the topics we discuss quite a bit on our show is the impact of artificial intelligence on the practice of law. Have you incorporated any form of AI in your practice?
So I knew this question was coming because I've listened to all your prior episodes, and I still struggled to try to think of how I was going to answer it. The best answer I can come up with is sort of. Trial work is such a human field. You have to be able to stand up in front of the jury and deliver an argument. And it's interesting because I just saw a news article the other day about a pro se litigant who attempted to have an AI avatar deliver his arguments for him. So he stood up in court, told the judges he was going to show him a video, and then started to show him this video of a realistic looking person. And the judges immediately stopped him and said, who is this person? Is this your lawyer? If this is your lawyer, they need to be here. And the pro se litigant had to tell him, no, that's AI. I put my documents and my thoughts on this case into some AI system. I don't know what system they used. And it generated a video that they were going to show. And I think courts are not going to let that slide. They're not going to let us go that far, because I think at the end of the day, the expectation is it's 12 people deciding a case. That's sort of the fundamental bedrock of our legal system, is that the end all be all is the jury trial, and the jury is made up of people from the community. And so I think from one aspect, trial work is always going to be a human field. So that's why I say no. But then I also have to say yes, because there are places where I've incorporated AI to help review documents, where I've incorporated AI to sort of help me hone and develop my arguments. I haven't gone as far as to use AI in writing any briefs, but I've definitely used AI systems to help craft out letters and make my writing more polished and a little bit better. But obviously always subject to, you've got to use some guardrails and make sure that you're checking that and make sure it's actually my voice at the end of the day. It's actually my words.
I think you really hit on something, and that is that the use of AI for purposes of demonstrative evidence in trial is going to become very important. For example, I could see how AI can be very instrumental in creating some type of a 3D model that would be very helpful to a jury. course, all of the foundational requirements would have to be established before the jury could see it. But on the other hand, with the technology, you can create deep fakes and you can very credibly put on something that never happened. And so I think that is something that the courts are going to have to deal with. It's interesting just to kind of muse about.
Yeah, I definitely see AI as a tool that I think is going to augment our ability to get ready for trials. But at the end of the day, you've got that foundational question that a live witness has to answer, and that's, is this authentic? Is this a fair and accurate representation of whatever it's trying to depict? And I think that's what's going to keep AI from completely taking over trial work, is that, we can use AI to generate a more descriptive summary of somebody's medical history. We can use AI to analyze somebody's medical bills. We can use AI to create a model of an accident that can be created faster than any human could. But at the end of the day, someone's got to watch it and say, yeah, that's how the accident occurred. This video is a fair and accurate depiction of what happened. And so I think that's the guardrail for trial work, is that I have to have a human verify it. I can't just use AI by itself.
Are there any pro bono or charitable organizations that you are involved in your practice?
In my practice, no, not necessarily. I'll occasionally pick up a pro bono case. I'm a big advocate of lawyers as community members and community servants. And so I try to encourage everybody to get involved with something. We have a group in Kansas City called the Lawyers Association of Kansas City. And one of our big focuses is on community service, and not necessarily legal aid community service, but we go help Operation Breakthrough or the Humane Society or any other various causes. And we'll have a group of lawyers go out and walk dogs for a morning at the Humane Society. And we'll have them go out and we always put on this big Christmas party for homeless youth. And it's always a chance to give these kids an opportunity to just feel normal for a while, to feel like their life's not as hard as it has been. And I'm an advocate of that for two reasons. One is I think it's great for the community. But the other thing is I think doing the non-legal volunteer work really gives lawyers a chance to look out for their own well-being, their own sanity. It gives them a chance to do something where they can feel good for the community without feeling like the only good they can do is pro bono legal services.
Now, that ties directly into what I'm about to ask you. Have you ever asked that one question too many?
So I'm sure that I have, but I don't have any good examples of asking the one question too many. What I do have is I have a good example of a time I asked one question too few. And that was when I was in law school. I was in a trial advocacy class, and the end of the semester project was to do a mock trial. And I'm examining a witness, and I felt like I just knocked it out of the park. And then I stepped down, and the professor takes a break in the trial, and he looks at me and he goes, "Why didn't you ask him this?" And I said, "Well, I wasn't sure how you would answer, so I didn't want to." And he goes, "Well, that was the question." He's like, "It doesn't matter what their answer was. You had to ask him that question because either way, that was going to decide the case. So if you asked him that question, even if they said yes or no, I mean, you could have changed their answer. You could have argued their answer was whatever you wanted it to be. But at the end of the day, you needed to ask that extra question." And luckily that was in law school, and it was just for a grade, because that really stuck with me of, don't be afraid to ask that sort of closing killer question at the end of your outline, even if you're a little afraid of what the answer might be. Sometimes it's important to ask that. So I feel like, I'm sure there's been a time that I've asked one question too many, but really what stuck with me is make sure you don't ask one question too few.
Well, thank you for being with us today. Can you tell our listeners how to reach you?
Yeah, my email address is raine@knightandcastro.com, or you can also look me up on LinkedIn. I try to be pretty active there, and I love to interact with people on that platform. So if you connect with me on LinkedIn, I will be sure to interact with you as well and reach out to you. But as I said, also, if you have an actual legal question and don't just want somebody who's entertaining and fun to hang out with, you got my email address as well.
Thank you again, Phil.
Thank you.